Welcome back. It's Philip Bickle at Legal Tyranny. It's July 29th, 2020, and it's been a while since I posted anything because I'm still fighting with mold poisoning, and my head has been, it's just not been in a good place. But here's another case that deals with the same issues as the case with Albert Staff, but this case actually had everything resolved at lower levels, and the judges at lower levels agreed with the individual that raised the issues. Okay, so this is Los Angeles Times again, November 8, 1994. It's a long time ago, almost 20 years ago. These issues came up and then they got buried. Okay, so a ticketed driver takes a bite out of court that nibbled him for $10. Litigation. Small claims jurist awards $200 to man after Antelope Valley Traffic Court wrongly issued warrants for his arrest over a handling fee. And a quick reminder, this involves a municipal court in California, and municipal courts at some point, I don't remember the time frame when it happened, but they were either closed down or converted to superior courts, and municipal courts don't really exist over there anymore, not to my knowledge at least. So when they discuss the municipal court, at this point in time, you might be able to look it up, and it might be a superior court if you wanted to contact that court and see if they have archives of what was filed in relation to this case. If you want to get your hands on original documents so you're not dealing with any fudging of the facts by this LA Times reporter. And judging by the last name, there's probably some fudging of facts in here. Okay, so let's get going. Kenneth Dine, a North Hollywood contractor, let the registration lapse on his 1984 Pontiac. He was driving on the Antelope Valley Freeway when a California Highway Patrol officer nabbed him for the expired license plates and slapped him with a ticket. He promptly paid the registration fee and dutifully sent in proof that he had done so. Now, he had plates on his car, but if you have plates, you're also required to keep the registration valid. Otherwise, you got to take them off there because you're in violation of the law if you have plates that aren't up to date. Now, the whole commercial non-commercial issue is a totally separate issue to dive into. This guy doesn't dive into the commercial versus non-commercial business, but he does attack other procedural related issues. The response was not what he expected. A computer-generated notice said he now was charged with the crime of failing to appear in court, with a bail set at $364. Then came a bench warrant for Dine's arrest, with bail set even higher at $500. It took 2 trips to the Antelope Valley Courthouse in Lancaster before Dine finally sorted things out. Then, angry as hell, he sued for his time and trouble and won. In small claims court, he was awarded $200. The legal decision goes well beyond the sweet intoxication of righteous vindication. It spotlights the authority of court clerks and of the computers that do their bidding, a power that is largely unchecked. Even the supervising judge of the Antelope Municipal Court concedes that the warrant was issued mistakenly, under authority that the clerks believed they had, but as the Small Claims Commissioner pointed out, actually do not. When you start reading these California Vehicle Code sections, it's not quite clear. Judge William Seelig said, "You've got that right," said Dine, offering an essential truth. Just because somebody tells you to send them $10 doesn't mean you have to do it. It's not, Dine is quick to point out, that he is some wacko bent on raising hell. This, he says, was about democracy, about how traffic court is an essential institution where government power is felt most keenly by the largest number of people, and where it is most essential to stand up for one's rights. Now, this right here is one of the reasons why I targeted this area for activism. It's traffic court does affect the largest number of people, really. I mean, there really aren't too many other situations where people come into potential direct contact with uh, enforcement officers, and the issues that I raise tend not to have, I don't know, the no driver's license, depending on the state you're in, like in California, it did have the potential, I believe, for up to 1 year in jail if convicted of it. So that's not great, especially when you have severe health issues. I mean, it's not good. You'll probably age very fast, and in some cases, like the case of free speech activist and fighter for European peoples, Edgar Steele, um, that individual was framed for allegedly trying to bomb his wife, which very clearly people tied in with the ADL were the ones responsible. But they put this guy in jail, and he was in terrible shape, and they knew it from his medical records. He was a lawyer, and he wound up dying there, unfortunately. And hopefully his wife, Cindy Steele, is holding up. But when you take on these sort of fights, you want to study the rules. You want to have a game plan. Like, it's almost like war. You want to have a game plan. That's how these lawyers go into them too. Except for typical traffic cases, they go into this pretty unprepared. Just everything's streamlined. Any other larger cases, they have a game plan. They have objectives and game plans, and you should too. And if you can't get one formulated, don't try to make a stand on whatever that issue is, because you're just not ready. You'll wind up suffering punishment and not really achieving anything. Okay, so you got to test the restraints of democracy, he said. Otherwise, you lose your rights because they get nibbled up from below. It's not like Congress passing a big law that takes away your rights. It's these little nibbles. The nibble that ate at Dine began September 19, 1992, on the Antelope Valley freeway, when a highway patrol officer gave him a ticket because his license plates had expired. Dine paid the overdue license plate fee and, as required by law, notified the Antelope Municipal Court by mail that his plates were current. He did not, however, pay a $10 handling fee that had been tacked onto the ticket. He believed he was obligated to pay the fee, but after careful study of the vehicle code, to the DMV, not to the courts. On October 28, 1992, the court issued Dine a letter telling him the clerks were still waiting on the $10. On December 9, the court computer spat out a document entitled Complaint that charged Dine with the misdemeanor crime of failing to appear in court to pay the $10 fee. Bail was set at $364. Dine wrote in to protest. In January 1993, a court commissioner dismissed the criminal complaint, but reimposed the $10 fee, giving Dine until February 16th to pay. Dine did not appear. On February 26th, the court computer once again charged him with a crime and issued a warrant for his arrest. Bail was set at $500. Now Dine was wanted by every police officer in California for a $10 fine in a case that began with a simple infraction that had already been corrected. The legal basis for the warrant, like the complaint that preceded it, was the section of the vehicle code that makes failure to appear in a court a misdemeanor. However, in 1985, the state legislature added a section that expressly forbids such warrants on 3 conditions. The driver has a clean record, has a valid California license, and was initially ticketed with an infraction. Dine met all 3. How do you like that? This guy met all 3 of these things, and they still hassled him over this. They couldn't get their act together. They hassled him over it. Now, he can't get that time back. At least he did win in a small claims court, but still, $200 for the time running around. I don't know that that's even necessarily, I don't know that that's enough. And then the stress. Do they factor in the stress that causes? In such cases, the court is simply supposed to notify the DMV of the motorist's failure to appear. The DMV, in turn, is to collect any court fees when registering the driver's vehicles. That, the legislature found, would be more cost effective. And that was the point that Dine kept making in letters to the Antelope Municipal Court, but to no avail. On July 1st, 1993, needing to renew his license by his July 4 birthday, Dine finally trucked out to Lancaster in the Antelope Valley. He waited all day until his case was heard, he said. Late in the afternoon, he said a judge dismissed the warrant and told Dine to pay the $10. I have got to comment on this. They made him wait all day to hear his case. All day. I don't doubt it. Late in the afternoon. Now, what they don't say right here, and I'd bet my left testicle, what they don't say is that the courtroom was probably empty of other people, public. People tend not to just go out to court to observe these things. They are supposed to be open for us. I don't know what's happening with the whole COVID thing right now. I think the COVID thing is probably being used to make it harder for the public to get in there, because there are definitely a lot of people like myself popping up in the courts causing them grief. But the statistical odds right here are in favor of the fact that the judge was already aware that this individual, Dine, was going to be there that day. They might not have known about most of the other people, but this guy has written to them, and he had a number of appearances already. And he was raising very important issues. So, he stands out as an anomaly from the rest of the herd. Like, the rest of the herd just goes in and gets sheared. This guy, he's more like a sheepdog. So he stands out, and they would have known. And they would have probably, this judge that dismissed this probably would have told his clerk that was working in the courtroom that day, put this person last. We may have a lot to do, whatever their explanation is to that court clerk for moving him to the back. But a lot of times, cases like this, they know what's going to happen, and a lot doesn't need to go down. They just make a quick correction. In a lot of cases, they get these handled in under 5 minutes. But what they don't want is the public to see it. So, they'll put your case last. They did this with just about every appearance I've had in both the California court system and in the Hawaii court system after my first appearance. Once I made my first appearance and they realized I knew what I was doing and I was calling them on a bunch of stuff, they never, ever heard me before other people. It just didn't happen. And my last name's Bickle, starts with a B, so in both initial cases where I'd first appear, they'd hear me practically first, if not first, because of the B coming early in the alphabet, and that's how they usually do these things, alphabetically. But then they would constantly shift me to the end, because they did not want the public sitting there and hearing somebody that's well-read actually calling them out. And, whatever excuse they come up with, calling them out on that, too. So, yeah, I got to comment on that, and that's going to happen to anybody that does actually study things well. If they have the feeling that you're well-read, they'll tend to do that. Even if you're not well-read, they may shift you to the end just because, the people that go in that are trying to stand up but they don't study this stuff, they really do waste time. They waste a lot of people's time because I don't know how to put it. I mean, their heart's in the right place, and that's a great thing, but you got to get your mind in the right place too. You got to pick up the books. You got to start studying some. And yeah, I'm putting videos out, and I hope people can learn something from this stuff, but all of you have to get very good at picking out who's useful, who's giving you practical, useful information, and who's providing entertainment. Because the legal stuff, there's a huge number of people, and a lot of what is being put out is what I call edutainment, like education, entertainment. And some of these people, their heart is in the right place, but they also don't quite know what they're doing. They don't read enough, and law is all written. Every single law is written. So you have to actually read this stuff to go to the primary source. The primary source is not a person, it's a thing. It's written, it's on paper. And listening to videos like mine, you can come close to it, but you're not actually contacting primary sources. Even my scanned copies. So my scanned copies of certified articles, those would not be treated. They'd be open to inquiry, like as to whether or not they're authentic. If I was to take a scanned copy of something that's certified, because it doesn't have the imprinted uh, like certification from a clerk. It's not an original. It's a copy of an original, basically. So, for court purposes, like rules of evidence, that's how that would be handled. But you guys, if you start to learn this stuff, you'll be able to apply this in other situations, and it's useful because you can start eliminating things that aren't relevant better. And the court system is very good at distracting people. So if you have a court case and you've studied well and you have things written up and you know what you're going to do, drop a bomb on them, get them good on the first day. You can also let them step, in their own crap, if they wind up making the wrong moves, as part of your strategy. But your strategy should incorporate the knowledge that on the first day, if they don't know you, you haven't been through there before, you can kind of get a sneak attack in, just catch them off guard. After that, their guard's going to be up, and that's if you have to deal with them again, which you probably will. Okay, we're going to wrap it up here. If you found the information informative and useful, please give the video a thumbs up. If you're not subscribed, please consider subscribing. And if you are subscribed, please hit the notification bell so you know when I have a new video posted. And as always, if you can copy and paste videos that specifically would help certain people, that helps me out because this information isn't going to get out any other way. Thanks. Until next time.